Okay, so I get this question a lot. At what age can my minor child decide where they want to live? Okay, we're going to hit that question today. I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. So at what age can your child decide where they want to live? I hear a lot that there's some magical age in the statute, 14, 15, 16 years old. Well, there's no magical age in the statute. Under a Florida statute, section 61.13, the court has one of the provisions in the time-sharing provision, A through T, that talks about this. So the statute says that the court may consider the reasonable preference of the minor child as to where they want to live if the minor child is of sufficient intelligence, understanding, and experience in order to state a reasonable preference. Okay, so let's break that down. The first part, the court may, so it's not mandatory. It doesn't say shall, it says may, so the court may, and it's in the court's discretion, consider the reasonable preference of the minor child. So what is reasonable? So let's say the minor child says, I want to live with mom or I want to live with dad because we go to Disney every weekend, we get to eat out at McDonald's every night, we don't have a bedtime. We don't have to do our homework every night. And so if that's what the minor child says as the reason they want to live at that parent's house, then the court's not going to consider that reasonable. Okay. Now, even if the minor child is of sufficient intelligence or understanding or experience, again, the court has discretion, but most judges really don't want to put a minor child in the position of having to choose between one parent over the other. It can be emotionally scarring for the minor child. The minor child may have a strong preference at that point in time. Again, is it going to be reasonable? But so the court rarely allows a minor child to testify. So the court would prefer typically to have the child testify what we call in camera or in chambers. That means not in open court, not in front of the parents, so that they're not intimidating the minor child. And sometimes not even with the attorneys in the judge's chambers when the judge is asking the minor child. The judge would typically have his or her judicial assistant or trial clerk or somebody else in there with them, but would not do it for sure with the parents, almost certainly not in open court, and sometimes not with the lawyers. And if the lawyers are there, there may be some restrictions on the lawyers asking questions also. Okay. Also, judges don't really like minor children to testify because it kind of almost motivates the parents to try to manipulate the minor child's testimony. Well, you want to live with me because this, and this, and I can get you or give you this or that, and mom or dad can't give that to you, and I'll buy you this. And so the judges are reluctant to have minor children testify. So the way around that is that a judge is much more likely to appoint either a guardian ad litem or a social investigator. And then in the order, waive the hearsay rule. And the hearsay rule, hearsay is just an out-of-court statement offered to prove the truth of the matter asserted. So if the minor child were to tell the guardian ad litem, I want to live with mom or dad because of these reasons, the guardian ad litem would be prohibited from stating what the minor child told them if the hearsay rule was in effect, because it's an out-of-court statement offered to prove the truth of the matter asserted. So if that's waived, then the guardian ad litem or the social investigator can testify. Now, I think there's already a clear waiver in the statute for the social investigator, who's typically a PhD psychologist or a licensed mental health therapist, where a guardian ad litem can be a lawyer, social worker, something like that. So there's some safeguards in place there, but the courts much rather prefer that because, especially I think the social investigator who has the training can kind of dig down, take a deeper dive with the minor child to see if the minor child's being influenced by one of the parents to say the things that they're saying. If the social investigator or the guardian ad litem determines that, puts that in their report and recommendation to the court, then the court's going to become aware of that, and that will be held against the parent trying to manipulate, or it could even be called suborning perjury, meaning trying to get somebody to testify in a certain way that's not really truthful. Rarely done in this kind of situation. I've seen it happen in court many times, but not in this situation typically. But the court then doesn't have to have the minor child testify in open court or in chambers or in camera if the court has appointed a guardian ad litem or a social investigator in order to get what the minor child's preferences are and to see if they're reasonable. But still, it doesn't matter. It matters, but it's not dispositive or doesn't control the court what the guardian ad litem or the social investigator recommends, because the court still has ultimate authority to make that decision. Okay, so let's talk about one more thing. Despite the fact that there's no age specific in the statute, it's kind of true that in reality, when the minor child reaches a sufficient age and maturity, let's say 16 years old and they're driving. So they say, Mom, Dad, whatever, I'm not staying at your house now. I'm going to go live at Mom's house, or I'm going to go live at Dad's house. And that's just the way it is. Well, this is an interesting situation because technically the minor child's not a party to the divorce. And so the court may have continuing jurisdiction to do what's in the best interest of the minor children, but the court can really only order the two parties, Mom and Dad, to do something. So the court then has to make a determination, is Mom or Dad manipulating the minor children or preventing the minor children from actually going over to see the other parent, or not encouraging the minor children to go visit or to spend time with the other parent. So if you're in a situation where the minor child says, I'm not your mom, I'm not going to go visit with Dad because Dad pawns us off to third parties, isn't involved in our schoolwork or extracurriculars or spiritual development at church or whatever, and just is so disengaged, I want to live with you, Mom. And you're like, okay, well, technically I have to encourage you to spend time with your dad, but the clients cannot like hogtie the minor child and physically force them into the car and take them over to the other parent's house. So it's a fine line there. The court's going to want to make sure that you're not like manipulating the minor child to stay with you, or that you're even not encouraging the minor child to go spend time with the other parent. So that's kind of like without a supplemental petition to modify. So nobody's really filed anything with the court to change the time sharing, but the parent who's not getting time with the minor child could file a motion to compel or a motion for contempt against the parent the child is living with, suggesting that that parent is failing to encourage the relationship. Two different things: supplemental petition to actually file a new lawsuit to change the time sharing schedule, or a motion for contempt if the other parent's either preventing the minor child from spending time with you or not encouraging the minor child to spend time with you. Then the court can hold that parent in contempt if that is established and proven. All right, so I hope this has been helpful today. Please share this with anyone you think it might be helpful to have and to see, and hit that like button. I'd love it if you subscribe to the channel. Hit the bell icon so you don't miss any future videos. We're putting out new legal topic videos every Wednesday and new video interviews every Friday. So thanks for being part of the channel, and I will see you next time.